Thank you, James. What I'm about to recite to you is the true reality of how separation and divorce can have a detrimental impact on a child's life, a sad ending. Crystal's mother and father had broken up a few months prior and moved out of the family home, each going their own way. The family home was put up for sale one night. This home was engulfed in flames. Arson squad detective said it appeared that an accelerant had been used to start the fire, which quickly spread throughout the house. Crystal's body was found in the laundry. The laundry door was locked. Police said it was unclear why Crystal had returned to the house. She had been living nearby with her mother and brother. Her father was no longer living in the home. We all know the pain of family breakup, whether we have experienced it firsthand or have close friends who experience the searing pain that comes with it. It's hard not to see why a young girl would not return to what was once her family home and grieve. I only ask that you put yourself in Crystal's shoes. What would she have been thinking sitting there in that corner, remembering happier times or recalling the arguments and the unraveling of her family? She poured petrol throughout every home, every part of the home, every part of the room of her old home, then lit a match and resigned herself to death. Sadly, there are around 870,000, and that's a very conservative number, of children who will go sleep tonight in Australia without their mother or father in their home, just like Crystal. Many cry themselves to sleep, whilst others bury the pain through damaging addictions and or behaviours. Stephen Baskerville, former professor of political science at Howard University, wrote the following: virtually every major social pathology has been linked to fatherless children: violent crime, drug and alcohol abuse, truancy, unwed pregnancy, suicide and psychological disorders, all correlating more strongly with the fatherlessness than any other single factor. It is disappointing and inevitable and a tragic reality that divorce will always produce a certain amount of fatherlessness and or motherlessness. The key is to find a way to ensure quality for divorcing couples and justice for children, and ideally to reduce the number of divorces that take place and create legislation and services which foster co-parenting and relationships. We would desperately need a presumption of equal shared parenting after divorce and rebuttable based on mitigating circumstances. Nothing else will do. We laid this objective out in our 2003 12-point plan in the document Fathers in Families, Strengthening and Supporting Fathers and Turning the Tide of Fatherlessness in Australia. The new proposed anti-sharing parenting family law changes are an acquiescence to the unfortunate systematic biases of the family law system, which is directed against such outcomes. Tragically, this anti-shared parenting bias within the family law court is now set to become law. All children have that birthright to both their mother and their father. Might I remind the preamble to the UN Convention on the Rights of the Child, adopted in 1989, confirms this. Article 7 of the UNCRC confirms the biological birthright of a child to his or her parents. The child shall be registered immediately after birth and shall have the right from birth to name, the right to acquire nationality, and as far as possible, the right to know and be cared for by his or her parents. The biological birthright to both parents is further confirmed in the words of Article 9. Interestingly, Article 18, Section 1 of the UNCRC as well. As a human rights advocate and an advisor to various United Nations agencies and civil society organisations, I place my hand on heart and I appeal to you all that the ratification of a one-sided Family Law Act can have a detrimental harm through the potential infiltration of negative biases and inferences to stereotypical gender bias within our already failing system, at the unaffordable cost of our children and our futures. The removal of the presumption would limit the balance and the scope that courts are able to eventually narrow down on in terms of what is in the best interests of the child, and I say so as a lawyer myself. As they say, whilst this amendment may seem like a lifesaver for parents and children suffering from forms of abuse, such power may be weaponized in the wrong hands, again at the expense of our children, their upbringing and adulthood. Australia has a significant obligation as a signatory to the UNCRC since its ratification. Whilst consideration is placed under Section 60B4, the essence of the UNCRC must be enshrined within the Act, as the realms of divorce and separation continues to impact the futures of our children. The rights-based rhetoric within the presumption of equal shared parental responsibility is highly concentrated around the rights of the parents rather than the best interests of the child. This needs to be clarified to the Australian public. The removal of the presumption makes our children equally susceptible to rights breaches when in the wrong hands. And as per the Australian Law Reform Commission 2019 report, with the list of recommendations, Section 61DA ought to be clarified, not removed, and it ought to be interpreted with the rights of the children at the very epicenter of the parenting orders, rather than that of the parents itself. That is, that a child has a right to equal time and access to both parents, unless this presumption can be rebutted. Therefore, the presumption of equal shared parenting finds strong support from the UNCRC and by our nation's obligation to this convention, and it requires greater indoctrination within the Family Law Act. And for these reasons mentioned, and for many other reasons which I would like to discuss further, I am incapable of reiterating in my limited time. Dads for Kids reject this family law amendment. We rest our case. Thank you.